Well, I'm sitting here thinking, yes, yes, as I hear Ben and Gillian and Ellen, because I think that there is a commonality of view about this. I certainly, I think Ben's research is extremely important because what he says is the truth. This is when separation happens, even if it goes well, as I think one of the speakers said, I think it was Gillian or Ellen, it causes major emotional and psychological impact on people. But when it doesn't go well, it really does damage. There's a charity, Dads Unlimited in Kent, and I've heard one of the workers there speak, and he said, I joined up to be a support worker for separating parents, but I found pretty quickly I was working in a mental health charity. And so that's there. Equally, as Ben acknowledged, the accounts he's had from largely from men about their feeling that the family court is biased against them would equally be voiced if you interviewed a large number of women, and the harm panel collected a significant number of voices there who talked about the pro-contact culture of the family court, just as the other reporters talk about a pro-mum culture of the family court. And so there are perceptions that have been spoken of here, which I entirely agree with. I was fortunate enough to be drawn in by Ellen and her team in different stages of the Justice Report, and I'm on record as being very much in favour of what they described there. So I'm not going to give a long talk, because I think everyone who's connected with this and may watch the recording will agree that there must be a better way of resolving separation disputes between parents about their children than going to court. And yet, for decades, the default position, I think, of the police, of social workers, of others in society, if you've got a problem with your ex, then you go to court. As the Justice Report concluded rightly, that the court is necessary for the cases that need to go there, and access to justice is important. And where people can't sort out their problems, or one or other is simply not being heard by the other, there needs to be a mechanism for dispute resolution involving, in the end, a referee and a decision maker outside the family, who is the magistrate or the judge. But as I've said many times, that should be the last resort rather than the first port of call. And so the graphic that Ellen put up, I think, is very much what I've had in mind for a long time, that around the court in the middle, you have an apron going right around it, almost a physical apron where various providers have their stalls, and certainly there's not one size that fits all, but those separating ought to meander through those stalls and be exposed to information, to legal advice, to separating parent information programs, SPIPs, mediation, whatever it might be, to help them and support them to resolve their disputes without coming to court. And there's a book which it might at first blush seem odd for the president of the family division to have written the foreword to, but it's called Almost Anything But the Family Court. I hope those who are interested in this will know this. It's by Jo O'Sullivan, who's a solicitor and mediator, and she's giving advice to lay people as to what they can do without coming to court. What's been needed for a long time is a change of culture around all this. As long ago as 21 years ago, Sir Nicholas Wall pioneered a project called Making Contact Work, which was in part to do with what happens in court, but in a large part involved in identifying what needed to be done outside the court arena by government and other agencies to support separating parents. And in fact, this afternoon, I was brought up to realize just how long ago that was. The conference was in London at the Queen Elizabeth Conference Centre on the day of the anti-Iraq march in London. And I know that was 21 years ago, so I looked it up when I was giving a talk about this a few weeks ago. But today's been QC Day at the Royal Courts of Justice, and all the new QCs come. And one is a QC called Joanna Brown. And she reminded me that she came to that conference with her two baby twins, and I had my photograph taken with them. And she wanted me to have my photograph taken today with these two 21-year-old boys. And so they are a physical manifestation that 21 years have gone by since Nicholas Wall and others were calling out for government to do something. And yet, up until now, really that hasn't been taken up. I'm not saying it hasn't, because mediation is funded and other initiatives, but it hasn't happened. But I think your group is meeting now, and Mike Bell, you said in opening, that's the same as I've just said, that there's been a call for this for a long time, but nothing's been done. But I think things are being done now, and I think your group is meeting at a very important time. It's probably coincidence that you've come together, and various things have also been coming to the boil. But I think we're at a moment now that hasn't existed for 2 or 3 decades. And what I'm describing in part is the Family Solutions Group, which I hope you're all familiar with, their report, chaired by Helen Adam, who I think is on this call, called What About Me, which drew together the identification of all the sorts of things that might be done. It's really a companion piece with the Justice report. And those recommendations have been heard and taken up by the Ministry of Justice under successive recent Lord Chancellors, in particular Dominic Raab it was, who pressed the button on looking at this. And you will all know that the MOJ produced its written policy proposals in the conclusion of the consultation process in January of this year. And they've gone quite a long way to sign up to a number of the initiatives that the Justice report rightly identified, including early legal advice. And so I'm not going to go through all of those, but they're really important. It's an authoritative, independent web hub of information. It's family hubs, it's early legal advice, it's funding mediation, it's funding SPIPs, etc., etc. And in the budget, an extra 55 million was identified for family justice, and I think as yet it's got to be finally decided how that's split. But some of it is to support these initiatives, as I understand it. So something is happening after a long, long time when nothing was. And so if your report was in favor of that sort of initiative being taken up and developed yet further, then I think you'll be speaking in a context where an idea is finding its time. The second thing, obviously, I'm going to speak about is the Pathfinder court. And again, no need to explain it all to anyone who's tuned into this. But when we were developing the idea of the Pathfinder court, we thought it might work. We thought it might make a bit of a difference, and it was worth trying. But I think everybody who's worked in those courts in North Devon and North Wales and in Dorset is astonished by just the degree to which it has really changed the game for parents, for children, and for the court system. And the key difference is that before the very first hearing, the court has a detailed report from Cafcass or Cafcass Cymru on the impact on the child of what's going on in the dislocation of their family life. And it's effectively the information the court has now, 6 months or 9 months down the track in about 45% of the cases, upfront before they even engage with the parents. And that's very much what the Justice Committee, I think, identified, an information-driven process where the court are cited in detail with what's going on before they even start to engage with the parents. And I went, when I was at Dorset 7 or 8 weeks ago, the two legal advisors who gatekeep new cases coming in told me about the half dozen cases that happened to be in their list that day, and they each spoke about three of the cases. You know, one took three, another took three, and they spoke for about 5 or 6 minutes about the case, and they described. I think no one of the cases had exactly the same order made as any of the others, and it was a bespoke solution. In two of the cases, the final order was made without any hearing, giving the parents opportunity to come to court if they weren't happy with it. But the court made the decision. And I thought, well, if you went to an ordinary court now somewhere else in the country and asked the gatekeeper, legal advisor, or district judge to tell you about 6 of the cases that had come in, they'd struggle to talk for 45 seconds or maybe a minute because they would have very little information. They'd have the application form and maybe a statement or two in a rather confrontational way, as these things tend to be, more heat and very little light, but nothing about from the child's perspective coming in. And the game changer is that the court has got a detailed, independent, sophisticated view of the issue before it starts. I'm very, very keen on Pathfinder being taken up and rolled out, to use the jargon, everywhere. As you will all know, it's starting up in Birmingham and in Cardiff in, I think it's in May and April, in that order, in those two places. And that's not to see whether it works. I think we're absolutely sure it works. I've stopped trying to call it Pathfinder because we've found the path. We want to get everyone on the road now. The reason for doing it in these bigger places is that to see on a pragmatic basis what you need to do in the bigger courts to make it run, and also to see how you can deal with the backlog, because Birmingham's had to deal with its backlog before it can start. But again, there's some hope that this money from the budget might enable us to expand Pathfinder further. And so I think what I'm pointing to is that this push for parents to be supported in a wholly different way is now able to be delivered by government intervention, supporting parents before they come to court, because we can't do it. We don't know they exist until they apply to come to court, and through inside the court, dealing with these cases in a wholly different way. More widely, society needs to get hold of separation and supporting people. I think it's a bit like when there's a death in the family. I think people don't talk to their mates if they're going through a separation. It's all too difficult. And there's an initiative which you may have heard of called the Positive Parenting Alliance, which is aimed at encouraging employers to cut a bit of slack for their employees if they're going through a separation, just as they might do if their partner was diagnosed with a very serious medical condition or they were suffering a bereavement. And I think all of these initiatives are all part of the same. I think we just need to be able to encourage your group to push on and see this. Certainly, I'm very pleased this is an all-party group. This isn't a political issue. This is a human issue. What the court has been striving to do is solve a human relationship problem, dysfunctional relationships, with a legal structure. Well, that I can't think anybody would think is the best solution. It's a necessary one if you need it, but there's got to be a better way. And I think we're beginning to understand what that might be. So I'll subside now, Mike, if that's all right.
That's absolutely splendid. Thank you so much. I have to say, we are fully aware of the fact that several different things are happening. And so we've had to adjust the subtitle of our report to be interim, because things are changing so fast that it's going to be out of date all the time. So we now have a chance for some questions to Sir Andrew. We've got Nick Child from Two Wishes.
Thanks, and thanks, Andrew. I'm a child psychiatrist, retired, and I've got several lovely questions, but I shall just stick to the one given time. We've seen even tonight that it's tempting to call for a two-tier system, as many of us, as we can see, do. Family courts, if there's family violence or risk, alternatives where there's no such risk. But is a sort of logical puzzle that I see is there. It seems to me if family courts are a harming process, as you, St Andrew, have said, one that escalates tensions on its own anyway, then they surely pose the greatest risk of all for families where there are pre-existing risk factors, proneness to violence, mental illness, addiction, and so on. So if courts, I want to ask, are not the right process for low-risk healthy families or relatively healthy families, how can they be the right process for high-risk cases?
Well, I see the force of your point. With the Pathfinder, one real concern I had was that because most of the cases come in for this first hearing before the judge or the magistrates and are resolved at that stage, the court may be fudging or downgrading the importance of safeguarding everybody in cases where domestic abuse is a real factor. But I've been very struck by the way in which both Dorset and North Wales have got a very, very vibrant and productive and positive relationship with their local domestic abuse support professionals. And by the way, the National Domestic Abuse Commissioner supports this approach. I think the Pathfinder courts don't exclude domestic abuse cases. They take all the cases in. And as I understand it, and I haven't obviously sat as a judge in the Pathfinder, but as I understand it, part of the narrative is to accept that X or Y considers that they're vulnerable and should be protected from having any direct communication with or being in the same space as the other party. And the court isn't concerned in having a fact finding to find out precisely why that was, whether something did or didn't happen on the 17th of October last year. It encourages the other party to accept there is this vulnerability, and looking forward, arrangements have got to be made that assumes that there's a need to protect, and that's what happens. So I think I certainly agree with you that if there has been abuse, and sadly, very many of these cases, there has been abuse, the court process as it currently is played out now can exacerbate that abuse. And one hears all sorts of accounts of people, which I believe and accept, who've been re-traumatized by it all. And so if the Pathfinder can resolve the dispute without an elongated process that delivers further trauma, then I think that's all the better.
Just to say, I agree, Pathfinder, I think, makes the same point because it hands over a lot of the work to CAFCAS skilled social workers.
Yeah.
So they provide a much broader service than lawyers and judges can. Thanks.
Thank you very much. Next question from Sam Morphy. And I think this would probably have to be the last one, unless there's a really good question afterwards.
Might not be this one then. Thank you, Sir Andrew. I mean, we're a big supporters of Pathfinder, certainly in principle, and we look forward to seeing, the reporting further down the line on its success. I mean, has it actually been modelled on practice elsewhere so that we can see what success looks like? Is there practice elsewhere in another country on which either the principles or the actual practice of Pathfinder has been modelled, or has it had to essentially been done from the bottom up because of unique situations in this country?
I'm afraid I'm the wrong person to ask because I wasn't on the group that developed it, but I think it's homegrown largely, but it aims to be a problem-solving court in the way that the Family Drugs and Alcohol court is as well. It aims for the judge to not be very judgy, but to be more of a conciliator, to encourage discussion between the parties. So I don't think it is therefore similar to initiatives in a number of other countries. But I don't think we actually cut and paste a model from somewhere else. I think it was developed in different ways because our system has to operate. At the moment it operates entirely within the current law and with just a modest adaptation of the rules. And so I suspect it was homegrown because of those sorts of factors. The evaluation for Pathfinder, I think Ben mentioned that there are tenders out for further steps, but I think the initial evaluation is about to be published in the course of the next month, and so that will make it. I haven't seen it yet, but it'll make interesting reading.
Well, thank you very much. I'm going to break my own rule and ask a final question. One of the
that's because you think yours is the best question, Mike.
Okay, that puts me on the spot. One of the things that we've discovered in doing this this inquiry is the level of ignorance among parliamentarians. In fact, it seems to be almost or sort of tragically low. And it seems to me that this could be connected with the fact that the whole problem is so complex. Do you have any thoughts about how we can inform parliamentarians in a way that they're likely to understand?
Now, that's above my pay grade, and I think it's inappropriate for a judge to be making any comment about whether parliamentarians are well informed or not. It does surprise me to hear people in general, in the media, in Parliament, elsewhere, still talking about custody and access and using terms of that sort. And it surprised me particularly because parliamentarians of all people are being exposed to individuals with problems arising out of family court proceedings and similar difficulties. I imagine every week in their surgeries, and certainly on the group with David Norgrove, going back 12, 13 years ago now, we met a number of MPs, and they all said, and it was said that the Family Justice Review was set up because there was across the board feeling that the thing wasn't working because of the feedback MPs have. So if there is ignorance or misunderstanding, that's regrettable, because it is something that I would have thought they all think is important. Maybe a YouTube film or a video by your group explaining matters in a neutral way. I don't know. It's got to be easily accessible. And we've, again, talking about whether the time's right, there will be an election at some stage in the coming months. And often an influx of new MPs gives an opportunity to a group such as yours to put out material and briefing information to them. So maybe that's a challenge for you, Mike, and your team.